Welcome. Why don't we go ahead and get started, just because I know everyone's on their lunch break. And those who join in later, not a problem. And otherwise, we'll send a recording after this call. But super excited to have you all here. Good afternoon. And welcome to our live session today. We are going to be giving you all the info that you need for the upcoming Pregnant Workers Fairness Act. And just to note, this guidance is not legal advice. And so we do encourage you to seek counsel from a licensed attorney in your state or your locality if appropriate. Today's session, we're going to try to keep it no longer than 45 minutes. We will have two opportunities actually for a Q&A, so feel free to ask any questions in the chat box, and we're happy to answer those during the live Q&A portion. So let's go ahead and get started, and then we will have those two opportunities for the Q&A. So if you do have questions, keep them coming throughout the event. Thank you all for being here, and we look forward to hearing all of your great questions in a bit here. Thank you.
Hi, I'm Suzanne, and I'm 5 months pregnant.
My name is Kara. I have been breastfeeding for about 8 months, and I work as a marketing director.
My name is Mally, and I am mom to an amazing 9-year-old.
When I first found out I was pregnant, I was so excited to tell all of my family and friends the good news. The one conversation I wasn't looking forward to was the one I needed to have with my manager at work, who happens to be a male.
My daughter started refusing bottles. She only wanted to feed from the breast, which made it really hard to get back into the office. Even working remote, she needed to eat 3 times throughout the workday, so people were needing me during those times.
When I first went back to work after giving birth, my employer at the time did not have a dedicated room for me to pump in, so I had to sit in our mail room, which didn't have locks on the doors, the most depressing area of the office.
This being my first time pregnancy, I wasn't sure who to reach out to or where to go in order to get the proper accommodations.
This was really challenging for me to talk to my boss and my colleagues about as to why there were times where I needed to be a little bit late to meetings. I think if they had used something like Disclo, these conversations would have been a little less awkward and the transition would have been a lot smoother.
Luckily, I was able to make light of the situation at the time. However, if I did have something like Disclo, I would have definitely felt a lot more comfortable just asking for a private, dedicated space.
If I had used something like Disclo, I certainly could have avoided that awkward conversation and just felt more supported at work.
Oh, you're on mute, Hannah.
I was on mute. Look at this. We're 3 years into the pandemic and I still can't figure out how to unmute myself. Hi, everyone. My name is Hannah and I'm the co-founder and CEO of Disclo. I'm really excited to have you all here today. I would be described as a white woman with brown hair just below my shoulders. I'm wearing a white sweater and my background is just all a white wall. I'm in a new house and have not hung anything yet. I want to just give you a little background on myself and who we are and introduce you to our team. And then we'll kick off with today's event. And so wanted to just share my story and kind of why I got into this work. I was diagnosed with chronic Lyme disease while in college, and I had a PICC line placed in my arm shortly after my college graduation. So if you're not familiar with the PICC line, I was hooked up to IV antibiotics for about 8 hours a day, every single day. And as you can imagine, that was really hard for me to manage with anything in life. But I saw really firsthand how challenging it was to navigate the workplace. When I landed my first job in Washington, D.C. out of college, and at the time, I really didn't see myself as someone with a disability. And truthfully, I had no idea that laws existed to support people like me. And so after learning just how many people were living with chronic illness and disability, I was quite alarmed. That over 60% of adults were struggling with these kind of similar challenges as I was, and ended up joining forces with my now co-founder, Kai. And in 2019, we launched our first company in the disability space called Chronically Capable, which was a recruiting platform helping folks with chronic illnesses and disabilities to find and connect with employers who could be inclusive. And through running this business, we learned about the great challenges that people face in or that companies really face in administering accommodations for their employees. And on the other side, just how uncomfortable the process is for employees and job seekers as well. And so we launched Disclo this past summer, which is really a first of its kind, safe and efficient solution to manage your employee health disclosures and accommodation requests all in one dashboard and software. And truthfully, just for a second here, I kind of like to say that it's I pinch myself every single day because I have a dream job, just getting to help people like me with chronic illnesses and disabilities to navigate the workplace. I know how hard this is, and just getting to chisel away at the problem every day is super important to me. And so I'm so excited for today's conversation, and I'm grateful to be joined by Joshua Peterson, who joined us from Meta, where he served last as an accommodations business partner. Joshua is a very highly skilled and professional workplace accommodations expert. He's an HR professional and benefit specialist with really a passion for building compliance solutions to get the employee experience right. And so I'll let Joshua further introduce himself, but thank you all so much for being here. And for those who are just joining in, we appreciate you taking the time out of your day and look forward to this conversation. Take it away, Joshua.
Excellent. Thank you, Hannah. Good morning to our Pacific coasters, and good afternoon to the Central and the East. Joshua Peterson, as Hannah said, and I'm glad to have joined Disclo at the beginning of this year as the head of workplace accommodations and experience. I would be described as a white male with short brown hair and a short but full beard. I'm wearing a blue and white buttoned shirt. I'm in my home office, which has cabinet and office equipment and a colorful kind of mountain art picture behind me. So I have nearly 25 years of experience in multiple HR functions, including health and retirement benefits, leave of absence and time away program management, and accommodations program management. In these roles, I've done a lot of hands-on program administration and program management and a lot of case management work. So very familiar with the ins and outs and lots of specific situations and scenarios with accommodations. Bottom line, though, I've really built my career in supporting employers to have a compliant and relevant process that also gives the best employee experience possible. So my role at Disclo, I'm working with a brilliant and dedicated team, one of the best I've ever worked with, and getting to use my experience and expertise to help build a world-class disclosure and accommodation service. We're grateful to take the time today to have you join us and discuss some important topics related to reasonable accommodation in the workplace. Most HR professionals and company leaders know that accommodations is a sensitive topic and one that employees feel a lot of uncertainty around. So we're glad you're taking the time and to help, this valuable information is going to help your company if you're here as an HR rep or a company leader, and your employees to be much more successful in the workplace. So first, we're going to talk about the legal landscape leading up to the Pregnant Workers Fairness Act. And so first, we're going to do a little quiz, though, over in the Zoom chat. So get your Zoom chat open. We like to have a little bit of engagement. It's maybe lunch break for some of you. Maybe you're going to stand up and stretch. Maybe you're just having a late breakfast on the West Coast. So first, the first question is what ratio, meaning what out of 10, what number out of 10, 2 out of 10, 5 out of 10, 8 out of 10, 10 out of 10, what ratio of first-time pregnant women work until the final month of pregnancy? What ratio of first-time pregnant women work until the final month of pregnancy? Go ahead and put some guesses in there. We got Krista with 9 out of 10. Right out of the gate. 8, 7, 8. We'll give a second for any other guesses. 9. And the answer is 8. 8 out of 10. So way to go, Meredith and Kyle, getting 8 out of 10 correct. And the source is the U.S. Congress cited a survey in the Pregnant Workers Fairness Act, the actual language of the act, and you can find that there. So we're going to have another quiz a little bit later, so get ready as well. So now we're going to jump into the legal landscape behind the PWFA, some regulatory history, and some recent legislation that supports pregnant and nursing employees. So going, way back, a couple of laws that a lot of HR professionals are going to be familiar with. First, of course, is on the top of mind is the Americans with Disability Act, which was passed in 1990 and amended in 2008. The combined law is now referred to as the Americans with Disability as Amended Act, or ADAAA, and it applies to private employers with 15 or more employees. It's always important to note, though, that 32 states and Washington, D.C. have passed laws that make the ADAAA regulations applicable to employers with less employees. In a few states, it's any employer with one employee. So you always want to, make sure you're checking your state regs and not just the federal regulations. Under the 1990 ADA and then amended, you meet the definition of a disability if you have a physical or mental impairment that substantially limits one or more major bodily functions. One or more major life activities. And then the 2008 amendment added a list of bodily functions as well. And so you meet the definition of disability there. And then prior to the passing of the ADA in 1978 was the Pregnancy Discrimination Act, which prohibits sex discrimination and pregnancy discrimination. And then, more recently, this year and last year is the PUMP Act and the PWFA. Now, you may be thinking kind of, some of these sound like they have the same language, right? It's pregnancy discrimination back there in 1978, and then can't you get an accommodation if you have, an injury while pregnant? So isn't that the ADA covers that? Why is there now this PWFA? So that's some of the things we're going to discuss here as we clear up. We're just kind of starting here at the top, kind of, 20,000 foot level, and then we're going to bring it in. So new regulations continue to be passed. And, it's kind of a constant thing for employers to need to keep up with. So we're glad to be here to help. A couple of recent examples that apply to pregnant nursing employees are the PUMP Act, which became effective right at the end of 2022. And it expands workplace lactation accommodations for nursing employees to include exempt employees. So previously, you may not have gotten break time granted to you if you needed to lactate or nurse pump, while at work for your nursing baby at home. This act provides protections for millions of salaried employees who were previously ineligible for such accommodations, and states when nursing employees must be paid for time spent nursing. If you're not aware of this, you're a salaried employee, you want to go check this out to see, if you're an HR rep or company leader, you want to make sure you're complying with the FLSA for wage and time of when you might have a nursing or lactating mom in your workforce that should be being paid for some of her break times while lactating. So the PUMP Act does apply to employers with 50 or more employees. So a little caveat there, smaller companies may not be in the clear on some of this. And then lastly, and most recently, is the Pregnant Workers Fairness Act. This is what we're going to spend our time discussing today. The PWFA eliminates discrimination and promotes employee health and economic security by ensuring reasonable workplace accommodations for workers not only who have a disability, but whose ability to perform their functions of a job are limited simply just by pregnancy, childbirth, or related medical condition. You do not have to meet the definition of disabled under the ADA, as we covered in the previous screen. So lastly here is just talking about, enforcement and enforcement and administration. Just like the ADA is administered by the Equal Employment Opportunity Commission, the PWFA, which deals with accommodations for pregnancy, is tucked right in with the EEOC here. All these and so it's important to know that, and know that the EEOC will enforce coming up in June 27th forward the requirements of the PWFA, just like they do the requirements of the ADA today. Now, one thing to note is that, sometimes all these regulations kind of seem far off, and that maybe, when you have the priority is running a business, making payroll and all that, that you don't have the time to really take the time to make sure you're in compliance with these laws. But we want to always encourage your company and anyone who can influence these decisions to take the time to make sure that you are compliant. We'll have a section later in this presentation specifically on how your company can prepare. And lastly, we just want to note that the EOC is not just this big enforcement arm looking to, drop the hammer on employers. They actually believe that most employers want to be compliant, and they provided guides and resources that help you interpret the regulations into compliance. We're going to share a link at the end of the presentation where you can find some of those resources from the EOC, as well as several resources and articles that we at DISCO have provided to help employers as well. So next, Hannah is going to go in a little more in depth on the specifics of the Pregnant Workers Fairness Act.
Yeah, thank you, Joshua. We can go to the next slide, actually. So just some kind of quick high-level facts about the Pregnant Workers Fairness Act. We'll be referring to this a lot as PWFA. It's kind of a mouthful, so bear with us as we say that. But the PWFA really seeks to kind of fill the gap between Title VII and the ADA to really ensure that pregnant workers are able to continue their jobs with reasonable accommodations for either these physical or mental conditions that are related to their pregnancy or the birth of their child. The law is going into effect on June 27th, so coming up in just under a month here, actually, now that we're on May 24th. And employers will now be required to engage in an interactive process to determine a reasonable accommodation. And this is going to be really similar to the same process for employees with disabilities under the ADA. And we'll get into that a little bit further in this presentation, but the PWFA specifically defines the types of conditions that do qualify a lot more broadly than that of a disability under the ADA. So if you thought the ADA was gray, this is going to be a little bit even a little bit more gray. And just to note, the PWFA only applies to accommodations. So the Pregnancy Discrimination Act or the PUMP Act or the Break Time for Nursing Mothers Act law, these will actually apply to any non-accommodation related discrimination cases. So this is strictly accommodations we're talking about. So right in the DISCLO wheelhouse. Now, if you don't mind, just go to the next slide for me, Joshua. So nearly 3/4 of working women are going to become pregnant while they're employed. Employers are going to have a lot of opportunity then to do what's right at the right time to really try to retain their valuable working talent. And most companies who do implement accommodations for their employees, they report that their employees are happier in their jobs. We see better employee engagement, productivity, and job satisfaction. All of these are improving. And this is when we were, doing research on disability accommodations, but the same, applies here. And accommodations are almost always a win-win for the employer and the employee. And we know from multiple employer surveys and research reports that have been put out that the majority of accommodations cost most employers nothing at all to make or to implement. And pregnancy-related accommodations are no different. Most of the requested accommodations are just kind of common sense things that when you even say, you're like, oh, of course, that seems like a no-brainer. But there are also legal reasons why effectively accommodating employees is important. The cost of failing to accommodate is honestly too great to ignore. I think, we've talked about that in the context of disability. Sorry, I just dropped something off my desk. But the average disability lawsuit costs $200,000, and many settlements have actually soared to over $1 million just due to these kind of large punitive damage awards. And so companies are often getting in trouble. And the reason that they're getting in trouble is due to the mishandling of requests or honestly poor storage methods. And so we know your secrets. Many of you are likely using a combo of sticky notes and spreadsheets to manage the accommodations process. And unfortunately, this just won't hold up. And as we start to see this bigger increase in accommodation requests, as we start to include those who are pregnant, it's, you really have to tighten up these processes. And so, as I covered, the majority of pregnancy-related accommodations do have no cost to the employer. As you can see on this list on this slide, the commonly requested accommodations related to pregnancy are things like the ability to sit to perform certain tasks, or having more frequent breaks or restroom breaks, or even reduction of strenuous activities, lifting. And if you're in an in-person job, it could be something as simple as having closer parking for that employee. There are accommodations that do have a cost. And one I do want to call out is I just recently learned about a new startup called Milkmate. They are the first FDA approved solution in this breast pumping space. And I love what they're doing. This is in no way endorsed or sponsored by Milkmate, but they've built these kind of rooms and setups for in office to have a private space for breastfeeding and pumping. I think it's a really awesome solution. This, of course, would have a cost, but these are the kinds of examples that we will see that are honestly most of the time no cost. So starting in late June, you will have to, Joshua, if you don't mind, just go to the next slide for me. There we are. So starting in late June, you will be required to abide by the PWFA. And of course, while it's important to understand the law and how we can be proactive with our solutions to this, it's also important to know what you can't do, of course. And these regulations are almost identical to the Americans with Disabilities Act. Under the PWFA, you cannot deny someone a job after learning they are pregnant. You can't force someone to take leave if an accommodation could be provided. You can't retaliate or interfere with one's rights. And another important one to note is that you can't ask for additional medical clearances that you wouldn't request from a non-pregnant worker. So if you have a documentation where you ask to verify someone's disability, if you're trying to get documentation for a pregnant worker, it can't be in excess of what you ask your non-pregnant employees. So we'll take a moment here to pause and see if there's any questions in the chat. I haven't been looking at the chat while I'm speaking, but just want to pause here and see if we have any questions, or we can also, if anyone wants to unmute themselves before we get into the next section, which is going to be talking about how employers can really prepare for June 27th when the PWFA goes into effect. So
yeah, we don't currently have any questions in the chat, but as Hannah said, if anyone chat, put a question in the chat, unmute yourself, feel free to ask real time. Just know that reminder that we are recording, so your video and voice will be captured.
And if not, you can also think of your questions and we can get to them at the end during our next Q&A. We wanted to make sure we weren't talking heads for 30 minutes.
Yep. Great. So we'll just hopefully that this means that the content is real clear and we're doing a good job covering it. And if there's no questions, we'll just move forward. So now we're going to talk about employer preparation. Very, very important, as the PWFA in conjunction with the ADA and the other laws do have new requirements on employers. But again, get your chat ready and fired up. We're going to do another quick chat poll. So this time the question is, according to one survey, what % of moms thought about leaving a job due to the lack of reasonable accommodations or fear of discrimination from an employer during pregnancy? What % of moms have thought about leaving a job due to lack of accommodations or fear of discrimination during pregnancy? 80, 70, 80, 75, 80, 60, 100. All right, 60. Okay, this one is actually 23%.
That feels low.
That feels low, right? So according to one survey, maybe not your friend circle, but yes, Kyle, it feels underreported. I agree. I thought that was a little bit low, but this is cited actually in the EEOC has a flyer, that kind of fact sheet flyer that can be downloaded off of one of their guides to the PWFA. And they cited that stat in there. It does feel underrepresented. And in my mind, though, even at 23%, thinking 1/4, if you have 1/4 of, right, agreed, Kyle. So if you have 1/4 of any group or group in your workforce that is considering leaving, at least 1/4, because they don't feel like they can get reasonable adjustments so they can continue working for a temporary condition, right? Or because they think they're going to be discriminated against for being who they are, right? Then you've got a problem. If you've got 1/4 or more wanting to leave for any reason like that, those are things that an employer absolutely can own and improve upon to make sure that that group of individuals feels accommodated, welcomed, that they're not going to be discriminated against in any type of employment practice or benefits for their own choices and, just being who they are. So with that, employer preparation, I think that goes into it, just a mindfulness there of how important those things are. So the how to prepare for implementation of the PWFA coming up in June. Just take this opportunity to kind of step back and review your accommodations processes to ensure that they are legally compliant with the ADA Amendment Act, other federal laws such as the PWFA, and any applicable state laws. So always follow the law, right? It's always the right time to do the right thing. A couple of tips there in kind of, making sure you're compliant. When you get any kind of request, accommodation request, a discrimination claim, filing a discrimination complaint, always respond in a timely manner, just confirming we received your request, we're reviewing it, you can expect an update within blank days, and then follow through. Ensure that your processes are well documented and easily accessible. For employers, this just shows that you're not, you want to avoid the perception that you're trying to hide something or make it difficult or infringe upon an employee's right to things that are entitlements like FMLA, of course, and things that are their rights under the law, like accommodations or other reasonable adjustments. Just to avoid the perception that you're hiding or trying to interfere, make it very plain, well-documented, easily accessible, right where you'd put your, hey, we want to tell you all the great benefits we have, employees, and all the time off and PTO and why we're great employers, and have HR policies and right in there, accommodations, leaves, FMLA, your policies that outline these types of things. And then ensure that the roles and responsibilities of the accommodations program are well defined. So who's going to do what when? For your internal staff working these cases and issues, that will reduce confusion and make your processes as efficient and effective as possible for both reducing your company's legal risk associated with discrimination claims and keeping your employees at work that is productive, engaged, and feeling valued. It just takes a little bit of being a little bit better than kind of the mass to really stick out and show your employees that you really value them. And you really want to keep them engaged and employed. So secondly is to train your managers and HR professionals. This is probably going to be a bullet point on every single presentation we do. Train your managers and HR professionals. They are your front line touch points with your employees. They're the majority of the time going to be the first ones to learn of an employee's disability, health condition, or pregnancy. So you want to know, make sure that they know how to respond. It is imperative that they understand both requirements of the applicable laws and your company's policies. Third, analyze, what accommodations your company could potentially provide to pregnant employees for any known issues. We gave a good little checklist earlier in the presentation of some commonly requested accommodations due to pregnancy or pregnancy-related conditions. You can consider your unique business and job roles and kind of, maybe what a pregnant worker may need to be accommodated in those roles. Never assume and never say, hey, we're going to give you blank because, we learned such and such condition. You always want to ask the question though, what can we do to provide support? Would you like blank? We could allow blank. Give them those options and let them choose. That just shows good faith effort by the employer. And then provide a safe process for employees to disclose. It's not a one-time kind of check the legal inclusive company box to have a self-ID process or, a push to disclose so we know what percentage of our workforce have identified someone with a disability past or present. So we can kind of, inform our policies, but make it welcoming to always have an ongoing discussion and disclose your disability or condition and have a request for accommodations or adjustments. And then, we said this in our previous session, it's worth repeating. Beyond all the legal things you can do, at the end of the day, when you respond, always respond with empathy. Remember that having a disability, a serious medical condition, being pregnant or having a pregnancy-related condition can be exhausting, and deciding to ask for accommodations can be a very difficult decision. So we always want to remind our employer partners and their HR reps and company leaders to respond with empathy and care. Next, we're going to examine a couple of situations where pregnancy accommodation or accommodations can go wrong and where there was discrimination. Now, it's worth pointing out, obviously, that the PWFA does not go into effect until June 27th. So we're talking about cases pre, and because in many situations right now, you can still file an EEOC claim of discrimination, although it may not be on the grounds of accommodation necessarily, right? So here's where some processes go wrong. So first, with Amazon, situation is a pregnant employee asks for an accommodation to not lift more than 25 pounds. As Hannah said earlier, some of these are just kind of common sense. Like it's kind of common sense that things get more difficult as things progress, and not lifting heavy weights just makes sense. So employee files an accommodation request. The internal accommodation consultant, grants and approves their request. However, when that came down to the worksite manager, they said no go and required the employee to continue to lift heavy packages. And would you know it? They unfortunately, and I know a little lighthearted here, but this is just kind of facepalm kind of thing. Really awfully, horribly, this employee had to require further accommodations because they were injured and ended up instead forced onto unpaid leave of absence. So, rightly, the employee filed a claim with EOC. EOC sued Amazon in New York State, and this is still pending and in process, so we don't know the outcome, but likely we can kind of figure it out. It's worth noting that this is 1 out of 7 disability cases in the past few years for Amazon. They're not running on a great track record. And while, large employers can kind of be punching bags sometimes, that is in no way our intention. But just to say that, some companies are really struggling to get this right with such large workforces, especially, and so many frontline managers. They really need to pay attention to making sure there's regular annual training, little refreshers, little situational, hey, here's how you'd handle blank, manager if such and such came up, and those kind of discussions that continue to get your frontline managers and HR staff on board with, how to handle various situations. Here's some headlines just to flash across. Unfortunately, not only does this affect your company from a financial standpoint or employee engagement perspective, it also creates a very negative perception of your company with the public and potential future employees that may decide not to apply for open roles when they can go out and just search and see that maybe your company isn't so accommodating and so understanding or willing to work with employees who have conditions that could qualify for accommodations. So next we'll go over another scenario here. This is with Ben-Har Office Interiors. They had a candidate who applied to a controller position through a staffing agency. Ben-Har interviewed this applicant multiple times and gave them really positive feedback. It was so positive that they decided to extend an offer for employment through the staffing agency to this individual. Once the agency said, hey, great, we're so glad that you've chosen our candidate. Just a side note, they are currently pregnant. The president of Ben-Har decided to rescind the offer and instead later hire a non-pregnant applicant. And of course, and rightfully so, that applicant filed a discrimination charge with the EOC. They had to enter into a consent decree with the EOC. And by the way, the consent decree is kind of the most powerful enforcement tool that the EOC has. It functions as a kind of heightened form of scrutiny of the employer's actions for, in this case, 3 years. It's kind of like having the government, not like in your back pocket, like you always know, we got to pay the taxes, got to make sure we're compliant, but like literally looking over your shoulder for your company's operations for 3 years. It's not something that, most companies would welcome, as well as they had to pay $90,000 in monetary relief to the individual. And the EEOC also required the company to distribute, update, and distribute and post a revised anti-discrimination policy and provide the EEOC with all past claims and future for 3 years complaints of sex or pregnancy discrimination. So whether something was founded or not, if there was any kind of complaint, you had to notify the EEOC timely and have them write up in their business while they're kind of examining this. Now, a company who fails in such a way as this deserves scrutiny. But just to say that do things right, there's lots of reasons for a company to do things right, treat their employees right, and follow the law to avoid repercussions with their employees, turnover, and perception publicly, as well as having government oversight with you for heightened scrutiny with you for a time. So lastly, sorry, we just want to touch on the interactive process again. This is kind of the bedrock of accommodations and the ADA accommodations process. It is the part that the employer really bears the responsibility for. You can't outsource this to a third party like you can your FMLA administration or timekeeping or something. This is a real important part. It's a discussion facilitated between the employer and the employee, and it's meant to find solutions. So solutions to determining if there's a reasonable accommodation that's needed to perform the essential functions of the job for the employee, and what accommodations would fit best. So when the interactive process is done right, it shows valuable employees that you support them, and it increases employee satisfaction. I personally, in my many years of managing accommodations programs and specific cases, hundreds and hundreds of accommodations cases, I've had employees tell me multiple times how much they appreciate their company engaging in a conversation. And this isn't meaning just those employees who, request a certain accommodation, the company examines and gives them the exact accommodation they asked for. It's even ones where we had to discuss, we had to think of alternates, do a trial of an accommodation. And it wasn't just, there was some, kind of bumps along the road a little bit in the employee's perspective, but they still said they appreciated the interactive nature and that the company didn't just say, not too hard, shut this down, can't have, go on leave, but they kept them at work, trying things out and kept them productive. And so employees really feel valued when they see that the employer engages and attempts to, in good faith, find a solution. And then lastly, as with the ADA, employers will be expected, and I apologize, I didn't forward on the screen here, my apologies. As with ADA, employers will be expected to engage in the interactive process with their affected employees. And as with ADA, kind of the devil is in the details. What is reasonable in a circumstance and what constitutes an undue hardship, such as granting accommodation, is not legally required, is heavily fact dependent. So what's reasonable, what's an undue hardship is fact dependent. And we'll just note that undue hardship is a pretty high barrier for most employers, and something that a determination that should be made very, very carefully. So Hannah.
Yeah, well, thank you all for tuning in today. We're excited to go into our live Q&A for the remainder of the session. If your company is feeling unprepared for managing this new influx of accommodations, we're happy to support or at least have a conversation with you. So feel free to book some time with us at this QR code here. We're now going to jump into a brief Q&A. So for those who have to actually hop off and get back to your work days, totally understand. Thank you for joining us, and we really hope to see you on the platform in the near future. But we plan to continue to have these educational live streams throughout the coming months. So thanks for joining, and we'll hop into the Q&A.
If you have a question, drop it in the chat. If you have relevant, question or discussion, feel free to unmute.
I'm also going to send some resources, follow-up resources in the chat for those who have to hop. We put together a folder of resources, so feel free to check that out as well.
Mm-hmm.
Thank you for the nice comments in the chat.
Yeah.
Anyone have, I'm going to ask you all a question then, if no one has a question just yet. Has anyone been thinking about PWFA in your current workplace? Has it been a conversation that's been top of mind for you all, or is it something you're just kind of learning about now? You can feel free to answer in the chat. Sounds like no one's been talking about it. That's okay.
So if someone said new,
Yeah.
I'd like to say something. It is very new, but it's just so hard to distinguish how it's so different from the ADA and from it being different from the EEOC. It's just the only difference I'm seeing is that they have to have an accommodation, but I just don't see how how you distinguish it from any other law already present.
Yes, I will let Joshua jump in on this, but I'll start. I think one of the
Yeah.
big things with the ADA is that typically these disabilities are ongoing, or for a prolonged period of time. And in this case, pregnancy typically lasts 9 months or shorter. So I think it's just to add on, because right now there was the Pregnancy Discrimination Act and these other laws that did support pregnant workers, but it wasn't specific to accommodations. The
Yeah.
law, if you look at it, is almost identical to the ADA. You're completely right about that. The difference in how we handle this is that we are now evaluating pregnant employees, which we weren't previously including under the ADA, and they now have this protection as well. So I think it just really expands who we're supporting. And Joshua, I'm sure you have something else to add to that, but
Yeah, 100% agree. And so the key is that it really, the PWFA strengthens the employer's responsibility to engage in the interactive process, as was noted previously. And then secondly, and then I'll kind of talk about them together, clarifies an employee does not need to have a disability as defined by the ADA. So previously under the ADA, you needed to be defined as having a disability. So a condition that interferes with life activity or major bodily function. With the PWFA, just simply pregnancy itself is a condition deserving of accommodations. So you literally can say, hey, I'm pregnant and I would like to have a stool, greeter. I'm a greeter at a restaurant who, you come in there, hey, how many in your party? Let's see, okay. I would like to have a stool to be able to rest when I'm not having to greet and walk, customers around the restaurant. So you don't have to, the employer doesn't have to, give you a medical condition, or rather give you a form to go validate you have a disability. What's your condition? You don't have to have like, oh, I have a torn, a blown disc in my back. Which is a condition I'm under treatment for in order to get that stool. Just pregnancy or pregnancy related conditions alone qualify you now to request an accommodation. Does that clarify?
Yeah, so they don't have to request if they want, like they wouldn't even fall into FMLA if they wanted to request leave, because they wouldn't even qualify for FMLA in the past. And now it's just, it just qualifies them on their own to have, an accommodation, even leave if they wanted to. Or is leave something not included into this?
Right. This is not necessarily leave in FMLA, because you can go, pretty easily from an accommodation to a condition that qualifies for FMLA or your company's leave policy. But this is not, all inclusive. This is specifically for accommodations to keep someone at work, right? For someone to kick over to FMLA or leave, you typically have to say, no, this is an undue hardship. This accommodation you're requesting is not reasonable, meaning it removes an essential function of your role, or it's an undue hardship. It affects the company's operating, and there's no alternate that we can consider. So interactive process is needed. So if an employer were to say, I'm sorry, this request you're asking is not reasonable, they can't just say, so if you can't do the work, then we can offer you leave. They have to now engage in an interactive conversation to say, sorry, we don't see that accommodation you're requesting is reasonable. What other accommodations can we see or consider that would allow you to do the essential functions of your role and stay at work, right? And so they have to engage in interactive, just like if today or 6 months ago or last year, you or I had a condition, a disability that was limiting our work, and we asked for an accommodation so we could stay at work. The employer can't just say, don't like that, go on leave. They'd have to engage in the interactive process, consider trade-offs, alternates that may be able to meet their request and those types of things. So it requires now the interactive process, and that pregnancy alone is a condition deserving of a request for accommodation. You don't have to be pregnant and prove you have a disabling condition separately defined under the ADA, not kind of considering the pregnancy on its own, just prove you have a disability. And that's really what you're requesting accommodation for, not just because you're pregnant. Does that make sense?
Yes, it does. Thank you so much.
Mhm.
It just, the only thing it doesn't make sense is how they spread them out so much, you know, like they spread out the laws so much. It's like, why
Like,
not make one law that just all makes sense to have them all together, you know?
Sure.
Have a
Why not have
pregnancy.
just taken care of this in 1990 or 2008, right? Just kind of included this. Now you're right. I get it. Yeah,
Yeah,
we agree.
thank you
But
so
it is an
much.
important update and does in something designated that's important to be aware of.
Thank you.
Thanks for that question. That was a great one. Any other questions? I know we're a little bit over time, but would love to answer any other questions that people have. Now is a great time. Otherwise, we're happy to, again, set up some one-on-one time with you to chat. Joshua and I are happy to make ourselves available, even if it's just talking through how your company is preparing for the PWFA. So feel free to set up some time with us here at the QR code on your screen. Any other questions? I'll give everyone 30 seconds. No? Okay, great. Well, thank you all. That wasn't 30 seconds, but thank you all so much for tuning in today. We appreciate you coming to our live session and for learning more about the Pregnancy Workers Fairness Act. Excited to be talking further about this in the next month and in the coming months, but appreciate all your time and we are looking forward to our next event.
Yep. All right.
Thank you,
Have a good one.
Joshua. Thanks all.